Welcome to the Florida Bar Podcast, where we highlight the latest trends in law office and law practice management to help you run your law firm. Brought to you by the Florida Bar's Practice Resource Institute. You're listening to Legal Talk Network.
Hello, and welcome to the Florida Bar Podcast, brought to you by the Practice Resource Institute on Legal Talk Network. This is Karla Eckhardt recording from the 2018 Annual Florida Bar Convention in Orlando, Florida. Thank you for joining us today. Joining me today, we have Denis. Okay, so what I want to talk about today is, first, you're going to tell us a little bit about yourself, and then we're just going to talk about really important topics that you've discussed throughout convention and what you want our listeners to know, because we really think it's important to get the word out there for people who have not been able to attend convention. So whenever you're ready. Okay.
My name is Denis deVlaming. I've been practicing criminal law for 46 years. Started out as a prosecutor. Now I have my own criminal defense firm. Board certified in criminal trial law, and I'm an adjunct professor at Stetson College of Law. So that's kind of my background in a nutshell. I like to lecture about case law. I have been giving the board certification case law for 26 years, and so the Florida Bar asked me to give it to the Florida Bar Convention today.
Great. And what are some of the major points that you discussed throughout that discussion?
My discussion today was only 50 minutes long, so I didn't have an opportunity to give a tremendous broad scope. But they asked me to talk about cases that came out of the United States Supreme Court of Import and the Florida Supreme Court, not the District Courts of Appeal. So I hit on some of them today, and there were about 175 people in attendance.
Wow. What would you like people to know that maybe you didn't get to touch upon during your lecture?
Well, let me touch a little bit about the most salient cases that came out of the Supreme Court, because I think your listeners would, want to know, the latest, as they say. There's a case called Pena Rodriguez versus Colorado that the United States Supreme Court that sort of changed the game in one particular area of the law. It used to be that the courts would not look into anything that a jury discusses during their deliberations in any respect, unless, of course, they got information that was extraneous, like they brought Google in or things like that. But other than that, they really were not allowed to go into that. Pena Rodriguez changed that because what had happened was there was tremendous jury bias and prejudice during the deliberations about Hispanics. And many jurors said that they wouldn't believe a Hispanic individual in any respect, and then they ruled against him because of his heritage. And a juror came out and told the judge about how bad it was during the deliberations. Well, normally, it's hands off. I mean, people can talk about what they want to talk about and even exhibit their prejudices and so forth. But the U.S. Supreme Court said we're going to draw the line, and we will allow the courts to go into matters where the jury makes their decision based upon a racial, or prejudice, involving heritage and so forth. So it was a game changer, but it was limited to those discussions.
I can't believe that actually happens. You want to believe that the whole process is very fair and unbiased, but of course it's incredibly important that, when you're judged by a jury of your peers, that you're not judged based on the color of your skin or, your heritage. That's just awful. So that's fantastic that the Supreme Court definitely decided to get involved in that. What other cases? So there's a few more cases, I'm sure, that you discussed.
I did. There was a case called Birchfield versus North Dakota. For as long as I've been practicing law, the law in Florida was that if you were under the influence of alcohol to the extent that you were impaired and you hurt or you killed another person while driving a vehicle, the police could ask for your blood, and if you didn't give it, they could hold you down and take it. They could literally, hold you down, put a syringe and take it. And the U.S. Supreme Court said that was a violation of the Fourth Amendment. Because it was intrusive, there was a needle that would put into your body, that the police now have to apply for a warrant to be able to get that blood sample. So if the motorist does not consent, and you can waive any constitutional right and consent, the police now have to apply for a warrant. Now, they did have one out, and that was called exigent circumstances. So, for example, if it was very rural and they couldn't get to a magistrate because it's an hour drive away, they would say that there was exigent circumstances and you could then take the blood.
Wow. My husband's in law enforcement, so I had an idea about that, but I didn't realize that there were exigent circumstances. So what would be considered as an exigent circumstance?
Well, there was a recent case, and when I say recent, I just read it the other day, where there was a traffic accident and it involved multi-car crashes. Mm-hmm. One of the persons involved was intoxicated. He was taken to a hospital. The police had to stay and treat the other people and conduct a vast, extensive investigation about how the accident happened. And between what they had to do at the scene and their obligations to the other people who were hurt at the scene and taking the defendant to the hospital, they said to be able to leave, run and find a judge and do it was not reasonable. And so they found there was exigent circumstances. Okay. It's on a case-by-case basis. Okay. And we'll see as the appellate court cases are decided.
Well, that's great. There's progress. And then I think you have one more case.
Well, I have another out of the U.S. Supreme Court, you're right, and it's Utah versus Strieff, and it's Strieff. That is a really another huge change in our laws, and it affects the Fourth Amendment. And what they ruled in the Utah case was if the police, they call the extenuation doctrine, if the police conduct a search, a Fourth Amendment search, that is unlawful, but the police conduct is remote in time or interrupted by intervening circumstances, they will still allow it. What happened there was a guy was coming out of a crack house. Mm-hmm. The police wanted to question him, but they had no reason to believe he had bought any drugs or done anything wrong. So they stopped him. That's called an investigatory stop, to investigate. Well, you need probable cause. Right. So if you search somebody in that case, the evidence gets thrown out because you had no right to stop him. But what happened was they did stop him, they did search him, they did find drugs, but they also, when they ran his name, found that he had an outstanding warrant, which would have allowed an arrest. So they allowed the drugs into evidence and said the Fourth Amendment does not apply. So it carved out an exception to what normally would be the exclusionary rule.
It's a slippery slope, though.
It is a slippery slope. It is. I will tell you, the law would have been different had there not been a warrant outstanding for him. Okay. Then they in fact, even the government conceded there was no reason to stop him, no probable cause to stop him. But they argued because of the intervening circumstance that it was okay. So if there was no warrant, it would have been thrown out and it would have been suppressed.
Incredible. Exciting stuff. These are things that people watch on TV and they think only happen on TV shows, but it happens every day.
It does. It does. And, parenthetically, Karla, I get asked a lot about the case that they're bringing to me is going to get dismissed because they didn't advise me of my rights. Mm-hmm. They didn't give me any Miranda rights. And they think that not giving the Miranda rights means the case is going to be dismissed. Mm-hmm. It doesn't. Right. It only has to do with the confession that they gave or didn't give. Right. So. Yeah.
And oftentimes, and again, bringing my husband back into the conversation, he's in law enforcement, they have Miranda written on a little card. And a lot of times people think like, oh, you're in law enforcement. How could you not have that memorized? The point is precisely so that question doesn't come up. So they can't say, well, they didn't read me my rights. So they can't say that,
Or they didn't write them or word for word.
Right.
Or you missed this phrase. Exactly. You didn't say that he could have a lawyer while questioning. Exactly. So you're right. We have the same thing.
So it's incredibly important that everyone cover their bases. So before we close out, I have one more question. If our listeners would like to follow up with you about topics we discussed today, how can they reach you?
Probably the best way. I'm an email junkie. So, probably email would be the best way. And that way I can look at it when I had time to look at it and respond. My email address is my name. So it's Denis with one N, DENIS, at deVlaming, DEVLAMING.com.
Perfect. And just a sidebar, I would be remiss not to point out you are an email junkie. We're all about mental health and wellness. So don't let your emails drive you crazy, everyone. When people email you, take your time. All right, well, this has been another edition of the Florida Bar Podcast brought to you by the Practice Resource Institute on Legal Talk Network. I want to thank our guests for joining us. And if you liked what you heard today, please find and rate us in iTunes. I'm Karla Eckhardt. Until next time, thank you for listening.
Thanks for listening to the Florida Bar Podcast, brought to you by the Florida Bar's Practice Resource Institute and produced by the broadcast professionals at Legal Talk Network. If you'd like more information about today's show, please visit LegalTalkNetwork.com, subscribe via iTunes and RSS. Find the Florida Bar, the Florida Bar Practice Resource Institute, and Legal Talk Network on Twitter, Facebook, and LinkedIn. Or download the free app from Legal Talk Network in Google Play and iTunes. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Legal Talk Network, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.